yours, and we're all listening.
So just to start, deux choses d'abord. La présentation va être en anglais, mais si jamais ça vous tente de poser une question en français, allez-y. J'ai aucune hésitation de répondre en l'une ou l'autre de nos deux langues officielles. Second thing, questions in general, regardless of the language, feel free. Ask at any time. We're going to basically go through a Word document. Like you'll see, it's not a PowerPoint deck. It's actually a Word document.
Oh.
That's okay. The table's big enough. I don't think it's going to spill. So all this to say, we're going to be going through this. So I'm just going to scroll down. And all you guys have to do is say, hey, stop. What about this? There's a word there I don't recognize. What does that mean? If you got any questions, just ask. Slight amount of jumping around at the start. You see, we're not going to go through all of the definitions. Some of them will only make sense in context, so we'll come back to them. But other than that, we're really just going through a Word document together. So if at any point you want me to drill down and you have a question, please just stop me and ask. So one note before, yes?
Will that document be available somewhere for further reference?
Sure, but just to tell you, like, this is a fake document. I've stitched together sort of a Frankenstein monster with deliberate problems left in so we can talk about them together. So this is not a good model. I don't think you can use this for your own purposes, and that's a good idea. I really don't. Like, I'm happy to give it to you, but please don't use it, because it was never designed to be sort of a good contract, especially from a developer perspective. Because we're going to talk a little bit about the indie publishing model, what works, what doesn't, how it's better than the traditional publishing model, or how it looks different but is essentially the same from a developer's perspective, and that's one of the things this is designed to illustrate. So I can do it, but I don't recommend using it. And just before we do get started, the layout here, there's no magic in the format of a contract, but one thing you'll see in a lot of contracts is that unlike this one, they'll be sort of divided into two parts. One part will be called like the business terms, and it'll be a one-pager on the front, and it'll have really just the most essential things that they want you to know, like when's the game got to be delivered, what platforms, and how much money are you getting paid. And we'll try to convince you, let's just talk about that one page. Ignore the rest. Don't go into the legal terms that come after it. Let's just talk about the business terms. That can be a way to keep you from looking too closely at what comes next. Always keep in mind that everything in the contract is negotiable. No matter what they tell you, there's always some flex somewhere in the contract, whether it's on the money or on the delivery times or stuff in the legal terms. So don't be put off or dissuaded from reading the whole thing and asking for changes or asking for clarification on the whole thing. So here I haven't set it up to have that distinction, but don't let that distinction be a trap that keeps you focused on the first page. Always read the entirety of your contract and always make sure the entirety of the contract works for you. So on that note, most contracts these days have sort of a first paragraph that basically just says, okay, who's on each side of the deal and when was this contract signed. For the most part, there's no magic in that. You should make sure that the names all line up, that you're doing business with the person you think you're doing business with, and that your name's there. Because if they copy-pasted it from some other developing agreement with another developer, you may not have the right name there. So you see I've got a couple of fictitious companies here. And then sometimes there'll be in between the who are we and the what are we agreeing to, there'll be a section with a bunch of whereas clauses. So it's like, whereas developer has developed a game, and whereas publisher wishes to publish a game. Those are usually not particularly helpful. The idea is they're supposed to give you like the business context, what's going on, to sort of help everyone remember why this deal was signed. Often though, they're so generic, the fact that there's a game and someone wants to publish it, they have no value whatsoever. So you can usually skip over that. Similarly, those whereas clauses will end with sort of a one-liner that says for good and valuable consideration, blah, blah, blah. Again, that's just legalese that's a holdover from sort of either the Middle Ages or American drafting practice. You usually don't have to worry about that. When legal terms really do matter, when the exact words you use really matter, I'll try to highlight those. There's a couple of times when it really does. But for the most part, the sort of filler that goes between the parties and the obligation, you guys don't need to really worry about as developers. If there's anything, your lawyer should flag it to you, and that's pretty rare. So this next is definitions. Sometimes definitions get scattered throughout the contract. Sometimes they're all in one place. Mostly these are just for clarity to sort of make sure that when we say game, okay, this is the game we're talking about, this particular game. And when we mean the game, we mean not just the software, but everything embedded in it. So that's an example of a definition that's sort of helpful. Other times the definitions are actually pretty important. You're going to see later on that you've got an obligation to produce a version localized for one language. That language is English. So if something else is written there, like I said, English and French, you've got now two language versions you're expected to deliver. Equally, you see it says American English there. You might have localizations that vary. You could have British English and American English, and then maybe you'd have to vary the spelling. Or there may be something relatively sophisticated embedded in different types of Spanish, or Brazilian and Portuguese. So that's something you need to worry about to the extent that these terms will appear later and define the scope of your obligations. Typically, it's things like language, platform, the launch date, stuff like that. Then you get into, and we will come back to these two, financial definitions. You've got marketing expenses and net revenue. We'll come back to those when we calculate, when we talk about rev share, how rev share is calculated, how to make sure you're getting paid the way you're supposed to be paid. But pay a lot of attention to these, because these are defining your obligations in a really concrete and important way, even more concrete than picking the language. Because what counts as revenue, yes, there are sort of accounting and tax definitions, but if you guys sign a contract that has a different definition, that's what's going to apply. The contract's definition of net revenue is what matters, not what your income tax revenues are, not what an accountant would think. It'd be what do you agree to. As I say, platform, port, again, these are all going to like what are your obligations and what are you expected to deliver.
Can you go back a little to marketing expense?
Yeah.
Here you say expenses, it's all the expenses.
Yep.
Can they include their salary inside that, or is what they pay to something else?
So that's an example of something that's left a little vague here. You see this is a very circular definition. This was included as an example of a bad definition. Marketing expenses means all marketing, advertising, promotional expenses incurred by publisher. So it wouldn't include your marketing expenses. So it's just publisher. As a developer, you're cut out from this definition. And then to market, advertise, and promote the game. That could mean anything. And whether that vagueness is a problem depends on what we're going to do with marketing expenses. And just to jump ahead, you'll see that the publisher is allowed to deduct marketing expenses from revenues. So $1 of marketing means $1 less for you in terms of rev share. Then it starts to matter whether this is broadly defined or not. If you were able to define your own marketing expenses and you were responsible for this, maybe you don't care if it's vague. But if it's coming out of your bottom line, you start to care a lot more about how it's defined. So we'll come back to that because as I say, the financial definitions are absolutely critical because they're basically an equation that converts into money for you. I'll come back to that, but one last thing. Typically, you'll see a definition of the territory, and typically it's going to be worldwide, or maybe you'll see worldwide excluding China, or something like that. Typically, you'll just do one publishing deal, but maybe you've lined up someone who's going to publish everywhere except China. You have a relationship with a Chinese publisher, or you want to do a French language market publisher and an English language market publisher. All of those questions are things that could get fought out or defined in terms of the definitions. Having talked about the definitions, we're now on to delivery and milestones. This is a section where, and typically this is how it starts. First the definitions, then what does a publisher need to deliver, then combination of what else does a publisher need to do, how do you get paid, who owns the IP. Those are the things up front, sort of the core of the deal. And then later on you'll start to filter out stuff that's less and less business relevant, but more and more legally relevant if something goes wrong, if there's ever a lawsuit. So for now, we're in sort of the more businessy aspect. First thing you're typically going to see is that the developer has to deliver a series of milestones according to a schedule, and that schedule is usually outlined at the end of the contract in some kind of annex schedule, attachment, whatever they want to call it. So typically that'll be a timeline, and I haven't reproduced it because there's no generic timeline for a video game. It depends what state your game has reached. It depends how complex the game is. It depends whether you're going to have post-launch milestones. For example, mobile games, typically there's ongoing support events, whereas for most PC and console, that's less of an issue. But you'll have some kind of schedule that pairs, you have to do this by this date, and then crucially, if you do, we'll give you this much money. So the main thing to think about in Schedule A, and this is less something for a lawyer and more something for you as a business person, is what are the ways to chunk the game? What are the reasonable delivery timelines for each of those chunks? And do I trust the publisher? Because we're going to see in just a minute, the publisher is typically the one who's going to look at each deliverable as it comes out and say, yes, you've met that milestone, you've passed that gate, here's your money. Or, no, you haven't, I don't like what you've done, go back and do it again. Because there's a bug or an error, or this doesn't meet what I think of as a playable beta. That again, very, very much case by case, so it's hard for me to give you a general piece of advice about, well, it should be 30 days between milestones or 2 months or 15 days. It depends on you, it depends on your game. And really the legal language will only take you so far in your relationship with the publisher. In my experience, most of these kinds of issues, when things get delivered and whether they're approved, tend to be worked out on the ground without that much reference to the contract. People obviously are looking at the dates, but if ever they're sort of quibbling over whether a particular deliverable has met the milestone definition or not, yes, if you're dealing with Microsoft or EA or a very large American publisher who has a definition of a playable beta that's this long, their lawyers will be looking at it, they'll be cross-referencing what you delivered with the contract, but in a lot of indie publishers, it's more flexible. So generally make sure that what you have in the schedule makes sense, but just as important as sort of the legal text is knowing and trusting the publisher and having a reasonable timeline from a business purpose. Like know your own productivity, your own limits. What is a reasonable timeline that you can meet, reasonable gates for you to deliver? And you trust the publisher to use their judgment in approving or disapproving those milestones. So talk to other developers who've worked with them, see what kind of feedback you can find online. Look at how well the timelines have worked out for them in the past. Ask them. A lot of them are quite open these days with, here's the 12 games we've published so far. Here's how many of them were on time or on budget. See what you can get and then craft your schedule accordingly. Because one thing you'll see is that typically the publisher is going to be the one Yes?
Sorry, I
No, go for it.
It's just, I know a lot of games have flexible timelines that are subject for essentially like a more dynamic, evolving schedule. Is that the type of thing that you've seen kind of follow like, okay, here's the approval schedule we've agreed upon. 3 months in, it's like, hey, we got to push project deadline back 3 months. Do you approve to essentially a quick rewrite of the schedule, or is it just on the ground, like verbal contract? Yeah, that's fine.
So I'd say normally you want to get that in writing. I mean, just document in some cases, and email's usually acceptable. You'll see that when you get to the end of the contract, it says there's certain ways to amend it. Check your contract, see if they have those. Most of the time, if you fail to follow it, like this one says it has to be in writing and signed by both sides, but if there's an email exchange and someone tries to go back on that later, most judges are going to be very unsympathetic if that ever did go to court. But try to follow the procedures to the extent possible to avoid someone trying to be sneaky later. And also just so that everyone has a record, because if it ends up being a phone call and person A didn't really have authority to approve that, person A gets in trouble with the publisher. Oh, well, I didn't really say 3 months, I said 3 weeks. You want to just make sure that nobody can go back on what they've said because there's no record of what was actually said. In terms of pushing things back, it's going to depend on how much and how important your game is. If your game is the big one they're banking on, they're going to be a lot less flexible because that's going to be built into their revenue projections. Typically, if it's pushing a milestone back that will not change the release date, they may not care as much because then the revenue stream will start on the same day, and hey, all it means is they'll pay you your payment later. Anything that delays their payments or accelerates their revenue, they'll have no trouble with. The issue will be if you want to accelerate their payments or delay their revenues. So typically worked out on the ground, typically case by case, but ideally you start from something reasonable so you have as few of those as possible, knowing that inevitably there will be people who get sick, or there may be technical issues, or maybe the platform you're developing for suddenly announces a security update that for whatever reason screws up your netcode or something. There's always unpredictables, and we'll see at the end also you can try to plan for those with sort of a force majeure clause, which says if it's out of my control, you can't hold that against me. But related to that is, let's say you do deliver something and they've basically said, we have discretion to approve it, and you can try to put in good faith discretion or commercially reasonable discretion, but what it comes down to is they will make a call. And regardless of what legal words you're going to put in here, the publisher is still making a call. I like it, I don't like it. And as I say, unless you try to have a definition that's as long as this page, it's going to be a fairly subjective call, so it's more about trust than anything else. So once they made that call, the question is what happens next? Yeah.
Yeah. So in one of the contracts we signed, we wanted to address like the possible case of like, all right, what if like you're holding like you're not approving a milestone for like reasons of spite or basically non-legitimate reasons actually.
Right.
And they were like, okay, they added in a bit about like approved under good faith of all parties and such. Does it even address that problem of yeah, like oh no, like we're not happy, you still haven't done this one design change that even though we have no design influence on it, like there's still some C bugs or some D bugs in there, we're not going to approve it. Like okay,
right.
No, that's a full BS.
So that does address it in like a legal sense, but like practically speaking, if they're saying no and they won't give you your $100,000 milestone, like what are you going to do about it in the short run? That's why I say fundamentally this comes down to them making a call, and you have to be able to trust them. Because if they just refuse, you're going to sue them. You can do that, but like that's a long process. The game isn't coming out, you're not getting paid, and if you get the milestone payment 2 years later, your company's moved on in all likelihood. Like that game isn't getting released if it's all. That's what the problem is. For these kinds of issues, the enforcement mechanism is so slow relative to the development cycle that you can put that in, but what will that get you in like this 3 months following their rejection? Like zilch. What'll it get you in the 6 months to a year? Maybe you'll be able to get it, maybe not. That's the problem, is that enforcement takes time, so ideally you want a self-enforcing contract where everyone's interests align, and when you can't get that, that's where trust comes in. That eventually you could get something from the publisher, but if it's going to take too long, then it's not going to be relevant to this game being released. It may get you, a nice damages award later, but that's probably not what you want. Which then comes to, just as they need good faith in sort of approving things, you're probably going to have to rely on them for the correction and approval process. Typically, this will have a one-size-fits-all deadline. 15 days to revise the deliverable and give me a new copy. Again, that's something that tends to work out differently on the ground, because 15 days may be far too much time if the issue is some typos on the main menu screen, to far too little time if it's a really stubborn bug or a problem with a core component of the game. So you have a one-size-fits-all, but in practice, these things tend to be worked out case by case by the people on the ground. Just make sure that there's something in there, and make sure it answers two questions, which this one doesn't, which is, okay, we're iterating on this deliverable. How many iterations can we go through? Can I give you 8 versions of the deliverable? Most publishers are going to want to cancel at a certain point in time, and you'll want to make sure that this is clear. You don't want to get in a debate where they're like, oh, well, we think after three strikes and you're out, and like, where is that in the contract? And they say, well, look at the termination clause. It talks about material breach. We'll come back to that, but the term material breach can mean a lot of different things to a lot of different people. It's a deliberately vague term that you'll see everywhere. So if too many deliverables, too many submissions of the same deliverable is a problem, spell it out. And second, make sure that you have something that addresses what happens to subsequent timelines, because if you're busy iterating one deliverable and you're also expected to meet the next milestones, you're going to have a serious problem, because 2 or 3 15-day delays are going to push you perhaps beyond the next milestone, and often one milestone can't be completed until the previous one is. So think about that in terms of iteration. You're sort of stuck with something that looks like this, that's one size fits all, but at least try to do better than this, which leaves unanswered those 2 very important questions. And you'll see this is just something that talks about the launch date. A couple of things to keep in mind: soft launch, hard launch, either or. What about early access? Make sure everyone's aligned on this. Like, if you're thinking this is my early access date and they're thinking, no, the game is complete, ready to ship, not early access but finished, you're gonna have a major problem. So make sure that when you talk about launch, launch means the same thing to both of you. And it's also, in terms of soft launch, hard launch, make sure that whatever the publisher's marketing obligations are, those match up with this as well. Because they may be thinking this is a soft launch, we'll see how your game does, and then maybe we'll put some money behind it in terms of promotion. You may be expecting significant publishing support. So if you're signed up with a publisher because you want their advertising chops and their relations with the different platforms, that's the kind of thing you want to make very, very clear early on. And this is something that's just worth thinking about, which is here they've said, well, look, if a platform you have to be released on, which you'll remember was Windows PC, if it's updated, you at your own expense have to make sure the game continues to be compatible with the platform. Depending on what yes?
About the target launch date. Let's say that we have different SKUs, and we have different target launch dates for each one, and the publisher is the one paying for the ports. Should we break it down under 2.4 to kind of acknowledge that and not have problems, or do we put just the main SKU and
I would say it probably makes sense to be explicit about that, because surely you have your own internal planning documents where you think you're going to hit this platform at this date, and if you've already made those plans yourselves, you should share them with the publisher, if only so they can get their marketing support lined up so that it syncs with your release, because it doesn't make sense for them to start advertising on one platform if you're not there yet. So that's the kind of thing I would put in the contract, because that makes sure everyone's on the same page. Like, quite literally, this is the page and these are the dates. So normally I would do that, unless there's some reason to do otherwise, and like off the top of my head I can't think of one. Now, so as I say, typically first section, here's what you've got to deliver. It syncs up with an annex that sets out in detail all of the deliverables, the time and the money. And then depending on how long the contract is, you'll see something that follows it, which is like, here's the other stuff you have to do. And so this is sort of a potpourri of different things. So you'll see one of the things that you're being asked to do is any amounts that you're paid up front only go towards funding the game. Can't use them on other games, can't pay them out as dividends, can't use them to pay off loans. That's something to think about. If you have an accountant, speak to them and make sure that they can apply the payments accordingly. Because if you've basically got more money than a milestone is going to cost, you were hoping to use that money to do something else, this clause would say you can't do that. How will the publisher know? Hard to say, but if they do find out, you look pretty sketchy, because they can essentially paint you as someone who's trying to misuse funds. So always make sure that if you are being given money, there's no strings attached, or you know what the strings are, and they work with your cash flow plans. Oh, rev share, just obviously rev share, there should be nothing like this for rev share. Here, this is limited to the development payments you're getting. By the time it's rev share, the game is launched, there should be absolutely no restrictions on what you do with any more money that comes in. So if someone tries, you can just explain to them, I guess that's just not sustainable. Once the game is up and running, the money is what it is. Especially once there's been recoupment on their side, they really have no claim to restrict what you do with the money. Question?
Sorry, so your take on use of development payments is that is like a train wreck of a clause, because they're basically saying you can only use this cash to develop the product that we're paying you for, and you have no freedom to put it.
I wouldn't say it's a trainer. It really depends on your company. Like if you have a company that only has one game, this doesn't matter. You're really only going to use it for that purpose. But if you have multiple games, you're hoping to use game one's incoming money to finance the development of game two, that could obviously be an issue. This isn't necessarily a common clause. Sometimes there's a clause like this in the agreement, sometimes there isn't. So it's more just in your particular situation to think about, okay, how's my cash flow planning? Is it compatible with what the contract requires me to do? The other problem is, like I say, from a publisher's perspective, once the money goes into your bank account, they sort of lose visibility over it. So unless they're in auditing you, this is tough to enforce, but you don't ever want to be caught having been offside of this.
Are they allowed to ask for an audit?
So we'll get to that in the revenue section, but often what you'll see is if there's no audit right, then no, unless you guys are suing each other, and then once you're in court with someone, you have the right to sort of look at the relevant documents on both sides. Otherwise, yeah, they don't get to go through your books and records. Those are yours. You're entitled to say no, and actually, because we're in Quebec, there's a law that prevents the sending of business records outside the province. So that can actually be quite an effective tool to prevent some kinds of audits. It's a 50-year-old law. It was passed by Duplessis, but it's actually quite useful with Americans. Anyways, the point is that audit rights have to be bargained for. And you'll see that depending on who's paying royalties, typically the person who's getting the royalties will want a right to audit. So if you're the developer and you're getting royalties, you'll want to be able to audit the publisher. On the other hand, sometimes you see financing contracts where you're getting the money and then you pay it out to the investor. The investor will want the right to audit you. Basically, whoever's paying out the money typically has to prove that they're honest by agreeing to audit rights. If someone doesn't agree to audit rights, kind of, what are you hiding? What are you worried about? If the audit expense is on me, why do you care if I'm sending someone to look at your books? But that's something that if it's not bargained for, you don't have it. Copy of source code. This is something you'll see in some contexts, more typically sort of traditional publishing contracts with a large publisher who's going to own the software. But the main leverage is that you have as a developer is you own the source code, and you physically possess it. So they have the money, you have the source code. Clauses like this are designed to take away your leverage. I'll try to put that close to the top of the screen. They're designed to take away your leverage by giving the publisher access to the source code sort of on demand. And regardless of whether you guys are in a dispute about payment or anything like that, because once they have the source code of the most recent build of the game, a lot of your leverage goes away. So always keep that in mind, that something like this is not necessarily a deal breaker, particularly if you trust the publisher, but it is something that's going to reduce your bargaining leverage if there's ever a problem. So the example of the milestone.
Why does that? If they have the code, why it removes the leverage power in the shape? Why?
So imagine so let's take the scenario that was given of they're rejecting a milestone, I think this is BS, I say, you can say, okay, fine, you've got a non-working build of the game, you've given me $400,000 so far, you're stiffing me the last $100,000, I'm gonna walk away, you have nothing, you're down $400,000, you now have spent that money, you'll never get it back because you have a non-working copy of the game. On the other hand, if they have the source code, if they can then release the game themselves or pay someone $50,000 to tidy it up and release it, they now have the ability to start earning income. Your asset is sort of asset versus money. The same way that if, in terms of collateral for a loan, the bank wants to be able to take your car, because then it doesn't matter if you don't pay them, they can take your car, sell your car, and pay off the loan. A little bit like that. This gives you leverage by saying, you give me the money and I'll give you something else. And again, this is not part of the contract. No one's thinking that this is going to happen, but it's one of those practical not going to court scenarios. I had a client who was developing for an American publisher, and the American publisher says, you've got to use our development environment. You publish through, you develop through the web on our controlled internal publishing environment. They could lock them out like that, and they did one day. And they had full control over the code in real time. They just locked out my client, cut off all revenue payments. My client could do nothing. They didn't have control of the code because it was all on the publisher's servers. And the server, now that the publisher locked the developer out of the servers, handed it off to a cheaper studio in Eastern Europe, what are you going to do as a developer? You're going to sue them in the United States, you're going to pay a lot of money to a US lawyer. You've got no real leverage at that point. Whereas if you still had a copy of the code and they don't, then you can negotiate. And so that's why I say it's something important to keep in mind.
That was, I was going to ask, when there is a club to say that you have to give them the source code, that still doesn't mean they own the right to the source code. So
Exactly.
if you start using it, you can, it's still your property.
So those are two separate issues, and you're correct that owning the IP and the source code and having a copy of the source code are two separate things. And that's the very next section actually is going to address who owns what. But even if they own it, they will also may want a clause like this to make sure they can get a copy on demand. Especially if something goes wrong during development, that's going to be their best bet, because at the end of development, well, they'll have a copy anyways as the release copy. And same. So two last points before we get into the IP questions that people raised. One is tech support. Just be aware that if you have an ongoing tech support obligation, you need to make sure someone's available. Sometimes they'll get specific on this and they'll say like business days, business hours in New York or California, or if it's a British publisher, maybe it's London. Or if it's a Japanese publisher, they may want to be able to call you daytime Tokyo time. Make sure you can actually handle that and make sure you have enough people. If your game takes off or is doing better than you think, or just has a bunch of bugs early on and you thought that your team members would be available to work on something else, if they get dragged into ongoing tech support, you've got to be able to manage that because you're on the hook to give that tech support. Finally, something that you may see in some games, particularly more on the mobile space, is that you have to put in whatever they tell you to put in to help make the game commercially gel with their other products. For stuff like cross-promotion, for tracking usage by users, for advertising. Make sure you're okay with it. Typically you can't negotiate this because they want to be able to make your game work as part of their stable. But there's things you can put in there, like for example, it's on them to make sure this complies with privacy laws, because typically there's huge privacy issues with tracking user behavior, especially if you're releasing in Europe. So just make sure that's in there, and then they're going to, we'll get to representations and warranties, that they're going to rep and warrant that whatever they put in your game will not cause you any problems.
Michael, that one is more prevalent for mobile games, I would say.
Yeah, I don't think I've seen it. I saw it once in a 3D game, like a VR type game, and I wonder if that's just because the hardware is so new, the publisher wants to be able to gather some data. But yeah, I typically see that in mobile. You don't really see that on PC or console.
In the last company I work on, the publisher for PC game and console game wanted its own tracking user data and so on. So
Yeah,
it's
so,
exactly the same thing.
and the main thing there is privacy, that there's a huge number of privacy compliance issues, and you just want to make sure that the publisher's on top of that, and it's not your responsibility or your liability if something goes wrong. So, now we get to IP. And this is typically where the indie publishing model is different from the traditional publishing model. Traditional publisher is, I pay you, you assign the IP to me, I own the IP. The indie publishers say, oh no, you retain ownership. It's all yours, don't worry, it's different. Yes and no. So the first thing to think about is there's two sort of keywords here. One is assignment, the other is license. Assignment is just a fancy legal word for selling something, transferring ownership. It's just a word we tend to use for intangibles, like you assign a contract, you assign copyright, you assign an account receivable, whatever. Think of it as a sale though. It's like I used to own it, I assign it to you, you own it. Then you have license. License, think permission. You've all seen and used their license agreements. It means I'm giving you permission to use my software. I'm not selling you my software, then I couldn't use it, I couldn't sell it to anyone else. I'm giving you permission to use my software, to install it on your machine, etc., etc. So ownership, permission. But then there's this awkward middle ground, what's called an exclusive license. And that's what we're going to see in this contract and what you're going to see in most indie publishing contracts. An exclusive license is technically a license, but practically speaking is a lot closer to an assignment when you ask, how's this going to work out on the ground? Because an exclusive license is not just you telling the publisher, yes, you can do all these things, you can copy my game, you can put it on Steam, you can distribute it, you can promote it, whatever, but only you can do that. I'm not going to let anyone else do this, and I'm not going to do it myself. So the only person in the world who's allowed to use your game is the publisher, excluding everyone, including you. So an exclusive license from an economic perspective is basically the same as assignment. You're not allowed to sell your game yourself. You're not allowed to bring in anyone else to sell it. Only the publisher can sell it. So yes, it's not ownership. You still own the IP, but you have no right to use your own IP without breaching the publishing agreement. So that's really important. It's something you need to think about, because an exclusive license ends up having exactly the same effect as assignment, in that the publisher is the only one who's going to be working with the IP.
So if you go in China, for example, now, like most publishers I think will ask for that, right? Like exclusive distribution in China. And so how do you protect yourself from that, right? Like clauses that I could think of at the time were things like, well, if you don't actually publish it under that time, right, then that clause goes away with all of the contract
Right.
ends, and then we can get negotiated with somebody else. Is there anything else that you would typically ask to?
Yeah, so this is really good because you guys are thinking about the right things. I was going to come to all of that, but essentially at this point, your worry is only this person can use it. What if they sit on it? What if they don't support it enough? The best way to manage that is a combination of two things. One is to ask them to do concrete, measurable things, including things you can measure from a distance, like dollars of marketing spend, or they've got to reach certain sales targets, or they have to pay you certain revenue targets. And if they fail to meet those, then you have the option to terminate the contract. So typically some sort of minimum royalty payment is a good way to set it up. Like if for two royalty payment periods in a row, like 2 quarters in a row, we get paid less than X, then we can end the agreement. And typically that's good for both parties because if they're not making money, why would they want to keep the contract alive? So as long as you pick a reasonable threshold, and those thresholds, you can make it complex. It could be 2 periods of less than $10,000, or it could be in the first year you have to make this much, in the second year this much. You can have it escalating, you can have it go up and down because that's a typical sales cycle. There's different ways of setting that up, but essentially minimum marketing support, minimum sales, and you may want either specific launch dates in a country or by channel. So you may see China, there's a lot more storefronts than there are here, so you may be like, you have to be on 3 of these 5 storefronts by this time, 7 of 10 by this time, and you can layer these things on top of each other. The only thing that restricts you is what will they agree to and what's sort of manageable from your perspective. So those would be my recommendations. You can define it in terms of minimum sales, but sales can get tricky if they're selling a lot of DLC, so each user maybe is a high value, but they don't sell that many units. Often better to frame it in terms of revenue. That allows publishers to adapt, so whether they've got a freemium model, a paid model, just in-app purchases, whatever, advertising funded, revenue is typically most flexible. It won't cramp their style. Like if they're pure advertising and you ask them to sell a certain number of units, well, that just doesn't work from a business model perspective. So typically revenue targets. And then what level should that be at? That depends on your game and the market you're talking about. So in terms of specific language, you'll see this is set up as a confirmation that no IP is transferred. Developer continues to own everything. This is normal. Even if it just says an exclusive license, you should include one of these two to be sure that it's just hyper clear that everyone agrees nothing is transferred. And they should agree to this because that's their whole business model, that you own everything. Exclusive license, and one thing that's going to play between these two is what if you're reusing content or tools from your previous games? This is something, remember I gave an IP presentation here. We talked about foreground IP and background IP. So the foreground is the new stuff you're developing for a given deal, a new game. And then the background is all of the stuff you're going to reuse that existed even before you started this project and you might want to use in a future project. It doesn't make sense for you to grant an exclusive license on your background IP, because then that would be, remember, even you can't use it. So you'd be locking yourself out of using your own tools in your next game. So if you remember, we went back up to the definition of a game. It's a very wide definition. And it said some of these definitions only make sense in context. So this is the game and everything in it. So keeping that in mind, let's go back to the IP, right? They have an exclusive license over all rights in the game. That's a problem, because the game might include all your tools. So you want to make sure you can reuse the tools. So there should immediately be some sort of distinction here between what's new to the game, the new content, and any background IP that you're going to need for a sequel, for your other games, stuff that you've already used in another game, so it's already out on the market, so you can't give them an exclusive license because someone else is using it.
I mean, wouldn't that sort of mean you want to better define the game?
You can
like,
do.
So games should not be so defined, broadly defined as everything, but a game is this stuff, and then our tools are this stuff, and then sort of separate.
Yeah. That's typically the way you do it, is that we could tweak the definition of game. We could theoretically also introduce a separate definition that says exclusive license of the game except background IP, and we've defined background IP somewhere else. There's a couple of ways you can do it, but the main thing you need to do is to make sure that you carved out anything that wasn't developed for this game and only for this game. Yeah.
And then just pushing that a little further is like, I imagine you'd want a section that says, we reserve the right to use all foreground IP that takes the shape of tools, engine stuff, code for future projects. I don't know if that's me from across.
So I haven't seen that often because typically publishers take the position of like, well, you know, if you developed it and I paid you to develop it, like why I should own it, not own it. You know, I should get an exclusive because I paid you to develop it. I think if you a reasonable publisher would probably say, yeah, sure, you can use it, but they might worry in the back of their minds, what if it's like a really great tool and they start licensing it to third parties, or you know, I should be cut into anything we make out of that. Depends how conservative the publisher is. Realistically, I think they should agree to that, but I could see sometimes we'll get pushback.
Could we see an exclusive license to the publisher, but we keep the right to use it?
Yeah, you can do that. You can carve out, you can basically have an exclusive license and then a license back. You can even see that in assignment. You may assign something, they may license part of it back to you. So there's different ways you can set this up. The main thing to have in mind though is this concept of foreground and background IP. It can also be an issue if you've got a licensed game. You may not have the power to exclusively license everything in the game. You may therefore only be able to grant certain rights, like if you happen to be developing a game for Disney, or you had a right to say a novel, your friend's written a breakthrough fantasy novel and you're doing a game in that setting, you can only grant certain rights because you only have certain rights. So again, keep that in mind as well, that if not everything you own in your game, if you don't own everything in your game, you need to sort of modulate what you're purporting to give the publisher to match what you actually own. Other thing here is you'll see that this license is quite broad. It covers the game. We've already seen you may need to better define what the game is, then also related content. You remember that was like DLC, the soundtrack if you sell it separately, basically anything that's around the game, virtual currency, virtual items. This tends to be more important in mobile because you have in-app purchases and other broader content, which is often where the real money lies. But even for like a typical Steam game, you may be selling the soundtrack. The other thing you should think about is other ways to monetize that aren't just the content. If you've got a really great soundtrack and you put it on YouTube, obviously YouTube is paying you for every view. You can't do that because there was an exclusive license. So if you're planning to put your game soundtrack on YouTube, you got to make sure that that's carved out. That would be an example of some sort of exception to the exclusive license. Depending, I mean, Pyre has an amazing soundtrack and there's a lot of views on some of the songs there. So I imagine they make a reasonable amount of money off YouTube. You want to make sure that you're allowed to do that by the terms of your own agreement.
What about merchandise?
Good question. You'll see here that merchandising and film rights is explicitly covered here. That's potentially a problem because we'll come back to that later. But merchandising is given in the license, but it's not addressed in the revenue percent for provisions. And so we'll see there's three things that should always line up. The IP, who paid for the IP, and revenue share. And you want to generally make those things sync up throughout the agreement. I'll come back to that in just a minute, but you raise a really good point, which is here, it's clear that, okay, it's the game, but then also Americans will often use the term derivative works, like anything based on your game, whether it's a film, whether it's a book, whether it's a comic book or a card game or whatever. Here we've got merchandising rights, which is a fairly vague term. Typically you understand as some kind of physical product, like plushies or action figures or cards, whatever. Film rights. What if there was a book? What if sort of like think of the opposite of The Witcher, right? Rather than book to game, game to book. How does that fit in here? Not hyper clear other than the fact that would you say it's all the developer's rights in the game, so it probably flows through and capture the book as well. The other thing is you'll notice that it covers all distribution channels. Okay, media platforms, distribution channels. I couldn't remember if I'd left this in. I was thinking about taking it out. Derivative works is a very broad term. Anything based on the game now belongs to the publisher. So that's a good example that in this case, what seems like supposedly a developer-friendly license captures the work and then flows through to everything based on the work.
By there, derivative work, can we think about a spin-off game of that game?
Yeah, so here there's a bit of a carve-out back up top about ports, sequels, but normally derivative work means anything based on a prior work. So it's a legal term from American copyright law that captures anything that's largely inspired by or built upon a pre-existing work. So that would capture adaptations, sequels, expansions. So as I say, this is a very, very broad license. And now, if you are willing to grant them this, and maybe you are, there may not be anything wrong with this as long as you know what you're getting into. But then that equally broad license needs to match some other equally broad obligations on their side so that there's a quid for the pro quo. Because these things should balance and they should largely align throughout the contract. Right, so I was talking about a sequel ports localization. So this is a section which carves out certain IP rights and doesn't quite match how broad this one is with this one, because you've got a very broad license which would prevent you from doing many things, but then down here it's like, okay, well, sequels, ports, how does that work? You basically have an obligation to negotiate with the publisher first. That kind of term is pretty common. It's usually not there's not quite as much tension as you see here, but in general, there'll be an obligation to negotiate with your existing publisher if you're going to bring out anything new. The question of what is new, typically it's going to be ports, maybe not. Depending on how sophisticated the publisher is, they may not have thought of that. Localizations they may not have thought of. Like if you develop a French version of the game, but you don't have something like this to explicitly deal with that, figuring out whether you have to pay royalties, whether you have to go through them, can be a pain in the butt. It'll come back to the definitions, and it'll come back to how this section is structured. Because if the exclusive license covers it, you can't do anything about it because you don't own the IP, you're not allowed to commercialize it.
So how does that work in real life? Because like, it seems pretty easy to abuse it in a way, right? Like you come up with a sequel and then you just give a heads up like 45 days before you even wanted to speak with any publisher, right? And then you basically are already unreasonable or something, and then like you're able to speak with everyone. And so, like,
Sorry about
I don't
that.
know, I'm a bit confused by how publishers are going to reinforce that one.
Because development of a sequel is usually pretty public, if a publisher suddenly sees that a sequel's been announced, but they weren't involved, that's a pretty easy enforcement. The question of how you should agree with that, that's pure business. Like, do you know going in you're probably going to have a good enough relationship with these people that you'll be okay with it? The main problem with rights of first refusal is that people hesitate to get involved with you if they know this exists.
Right.
Because the advantage here is, like, let's say you get an unsolicited offer, you have to pass it over. You're not going to get many unsolicited offers by people who know you have a right of first refusal already granted.
Right.
Equally, if you want to approach people, you have to sort of pre-submit to your existing publisher. At that point, you should pre-submit just to run out the clock and then figure out whether they're willing to do it or
That was
not.
the question, so it seems pretty abusable in a way, right? Like that's...
It could be abusable, and that's the thing. You're basically agreeing not just to this game, but to future games. So you may want to play with this. Again, it often comes back to trust. If you've talked to a lot of developers who work with an indie publisher, and they all say they're great, and you think you're going to have a great experience, then this may not bother you. If you're less sure, if you've had to sort of take your second choice publisher for various reasons, or you just really need money, so you're signing this kind of deal in the short run, see if you can negotiate and narrow the scope of that. Yeah.
And if you really don't want to work with that publisher, once again, can you submit something unacceptable, that like an offer that we will not accept, and therefore?
You could try that, but then the problem is that's the offer you have to take elsewhere. And then,
$1 billion.
well, that's the thing. You can do that. You can generate an offer they won't accept, but that's theoretically the same offer you then have to make to other people, which they also won't accept.
It has to be the same offer.
That's how this is set up. That like if you want to make an offer, the first thing you submit has to match. So to find an offer that they won't like but other people will can be very difficult. So that's again where often for this kind of thing, check how long it is. Play with the duration, because typically these are going to cover the entire duration of the contract, which when we check the definition of the term, it's at least 5 years, maybe longer, since the game launches, which again, then there's this question, soft launch, hard launch, early access. This is a long period where you're locked in with this publisher. So again, you own the IP, but practically speaking, between the exclusive license and the obligation to go to them for sequels, what you can do with the IP is heavily restricted. So that's the main takeaway, is that the indie publishing system or approach, yes, it's in many ways more favorable to developers because you do have a bit more control, but there's also steps they take to sort of claw back a lot of what's been given to you. Yeah.
The first refusal, si le publisher refuse, est-ce qu'il peut refuser plusieurs fois, ou s'il refuse, il faut que lui le produise?
Dans le fond, tu lui offres, s'il refuse, tu peux prendre l'offre et la donner entière. C'est ça l'idée d'un droit de premier refus. Il est le premier qui peut dire non. S'il dit lui à ton offre, évidemment, vous développez le sequel ensemble, mais s'il dit non, tu es libéré pour l'offre que tu avais faite.
Est-ce qu'il est obligé de donner un nom par écrit, ou est-ce qu'ils peuvent attendre 6 mois pour te dire non finalement?
Ça, c'est quelque chose de précisé. Vous voyez qu'ici, il y a une 45 jours pour le deuxième volet, une offre qui n'est pas sollicitée, mais là, c'est moins clair. C'est juste que fallait que vous lui donnez ça. Ça, c'est une ambiguïté qui a été laissée par exprès. Toujours quand il y a un délai, c'est bien de préciser en jours si possible, surtout si c'est un délai comme ça où c'est juste lui qu'il faut qu'il fasse une décision d'affaires. C'est pas que lui, il en est livrable, il doit rien faire, il faut juste prendre une décision. Donc, c'est pas déraisonnable d'attendre un délai. Honnêtement, 45 jours, c'est beaucoup de temps. Je pense que tu pourrais facilement dire 20 jours, 30 jours, quelque chose comme ça. Because that's what it comes down to is, typically you'll also add in, right of first refusal, no unreasonable delay, or any refusal must be motivated. That applies not just here, but also to say the rejection of your deliverable. You normally want to say, you have to give me a detailed written list of why you rejected it, and it has to be in such detail that I can address those deficiencies in time for the next milestone. So when publishers take decisions, it's you want to make it clear that they have to give them to you in writing if it's important, and to sort of justify or motivate it. Here, their refusal, you don't really care why they refuse, so it doesn't really matter. But from some of the other decisions they're going to take, you want them to give backup in writing as to why they took them. So again, both of these clauses are designed to illustrate that, practically speaking, you may own the IP, but not really be able to do anything with it. So make really sure you know what you're getting into. Or at very least have good termination clauses down below. So now we're getting into the money. And this is a typical sort of setup where, okay, there's money you're getting paid per milestone. And this was the money that there were strings attached with what you did with it. Oh, sorry. And then revenue share following release. And so we'll get into exact definition of revenue share in just a minute. But this is pretty typical. They approve, and then there's a payment delay. Most accounting systems between 30 and 60 delays, or days for the delay. Make sure that it works with your cash flow. Like, you got to be able to make payroll. So make sure that if they say 90 days, but you need 45 or 60 in order to have a cash flow that will pay your employees, make sure you thought about that, because that's the biggest issue, is you run out of cash in time. If the cash arrives, you'll be fine, but if your obligations fall due before the money comes in, you've got a problem that's just as big as if the money doesn't come in at all. The other thing is revenue share split. So typically you'll see a model something like this, that the publisher is going to have a very high recoupment rate, or a very high rev share, prior to them making back their own investments. So that's both typically the investments they make in the game to finance the development of the game, and the marketing that they pay. Often it's 100%, often it's 80 or 90. So typically very, very high in the initial phase, because they want to make their money back, and the only way they can do that is by getting the lion's share of the royalties early on. Then as they get recoupment, it'll fall to some lower amount. I've seen often a 70-30 split, sometimes 2/3, 1/3. This tends to be negotiation, question of risk, how well known are you, have you had previous sequels, games with them that have worked well. Sequel, you can usually negotiate better deals, but often it'll be something like this. And then sort of in a best case scenario where the game does incredibly well, it can be 50-50, and sometimes, depending on how nice the publisher is, you can even flip to 70-30 in your favor. You should always try to put one of those in, just on the off chance you make the next Angry Birds. Why not get 70% of that revenue? Publishers will often be willing to agree to that, because they're like, probably won't happen, but if it does, we'll be making so much money, whatever. So put that in there, just ask for it. Because if you do happen to make the next Angry Birds, the difference between 50% of Angry Birds and 70% of Angry Birds is a lot of money. So put that in, like a best case scenario. If it never happens, doesn't matter. You've still got this. But if it does happen, you will thank yourself till your retirement that you put that in.
This 100% stands out to me, because if you are basically spending, like within this contract, you're spending all of your development funds only for the development of your game, your cash flow's pretty low, you then launch and have nothing coming in.
Yep. So that's something to think about, is if you are locked into just financing this game, do you have enough to survive this period? And it'll depend on your revenue projections, it'll depend on whether you have revenue from other sources, depends on a lot of things. But one thing you can do is, when a developer has sort of two sides of the scissors closing in on you, you can use one and negotiate the other. So you can tell them, look, if you want me to agree to this, you have to give somewhere else. Or I'll agree to the restrictions on use, but this has to be 90%, so I at least have some money coming in. So whenever you feel like you're being caught in a bind, from a negotiating perspective, try to use one part of that dilemma to opt to negotiate the other.
Yeah, and related to that is, you can work in post-launch milestones that are part of the development budget. Right, so you can say, well, even though the launch sheet is this, because we're going to work on updates and add new character, or whatever's going to happen post-launch, the publisher still needs to include those as lump sum payments on its own milestone schedule. Even if the game is out there live generating revenue, the reality is you're not seeing money for 60 to 90 days, right? Because Steam has its own delay, then they have their delay, plus there's the replace. So you're not seeing money for months and months after launch.
Yeah, and there's two pieces that I want to pick up on. So the first one is a really good point, that you can structure the milestones. Like, I don't have a Schedule A because it depends on the game, but in our imaginary Schedule A, you could make sure you could plan some DLC with the publisher from the beginning, so that you know within 30 days of launch, you're going to put in some new characters or some cosmetic skins or whatever in order to generate another lump sum payment. And whether that will ever pay for itself doesn't matter, it just gets added into the recoupable amount, but at least you're getting a financial shot in the arm during this 100% recoupment period. Yeah.
In that example, I guess the publisher pay 100% of the production, and that's why you start something
Yeah,
like that.
yeah.
And if they don't, let's say they pay marketing,
Mhm.
and they give you 25% of the production
Mhm.
cost.
Sure.
So what would be reasonable to spend as a
That's,
split?
that would depend on how much the 25% is. That's how sure they are that this is going to be a success. So I agree in those circumstances, it should not be 100. That would be completely unfair. Should it be 25%? Should it be 50? I don't know. It's hard to answer a question like that in the abstract. And it's also a question of negotiation. If you have leverage over them because you have a really hot game or they knew you were competing with multiple publishers, try to work that out ahead of time. But you're right that the less they put in, the less they can ask for at the end as well.
Yeah, I mean, as a sort of, I mean, it's super rough rule of thumb, but normally the starting point is the share of the budget. So if they're putting in 50% of the budget, then the first point of red share is 50%, and then you step down from there.
Yeah, I'd agree,
I
unless
mean,
there's
it doesn't always
weirdness
work
with
out
the
that way,
marketing,
but
or
that's-
or particularly powerful one of the, but that's a pretty good, I would agree that that's a rule of thumb, that's where you should be starting from. So if they pay 25, whether they get a third because of the marketing or 40%, but probably not 50 and definitely not. So again, keep in mind, now we're gonna jump back up to some of the definitions that you see here, because we talked about marketing expenses, we talked about net revenue, so just keep the split here in mind.
Question here?
Yeah.
Question par rapport au dernier point.
Oui.
Dans les cas où le publisher fournit de l'argent de développement et aussi de l'argent de marketing, on a vu plusieurs modèles de rev share. Certains demandent le recoup seulement du marketing, alors que, par exemple, c'est 100% du marketing, puis après ça, on fait un rev share basé sur le pourcentage d'investissement. Certains mélangent les deux, on a vu plein de choses différentes. Est-ce qu'il y a des bonnes pratiques pour ça, des choses auxquelles faire attention?
Ben, l'exemple où c'est 100% marketing par la suite, une split, ça c'est assez favorable pour vous. On va voir qu'ici, c'est plutôt, on met en égalité les deux, que ce soit un dollar de financement de développement ou un dollar de marketing, les deux sont traités de la même façon. C'est toujours une question de détail. I think when we work through this, you'll see the advantages and the disadvantages. Typically what I've seen looks more like this, where everything gets put into the same pot, and then you use that pot and you split it according to a formula. But it can get very complicated, and the best thing to do is to try and work through the numbers and make some assumptions about how much your game will make some assumptions about how much they'll spend, and see what the numbers look like, and then try it with a different model and again work it out. It's again unfortunately hard to answer that in the abstract. Yes?
Yeah, I was just thinking again about marketing expenses. Because again, it's really vague and you say nothing about that. Should we write something in the contract to limit how they can include those?
So I would say when you get to marketing, there's probably 2 or 3 important things to think about. One is, do they have an obligation to spend at all? Here there isn't one, and actually buried in the exclusive license provision, if you look at the last line, provided the publisher has no obligation to exploit the game or exercise the exclusive rights and license granted hereunder. So that's the kind of bombshell you want to make sure that you see. If they don't have an obligation to exploit, that's why you need good termination provisions. That say if you ever fail to commercialize this game effectively, contract is over. Equally for marketing, if it just says marketing expenses but there's nothing that obliges them to do it, you run into the same problem. They could spend, they could not, and you have no way to sort of tell them, you guys agreed to this, come on, we're in the contract and we agree to this. Typically, you'd want to be explicit about how much they need to spend. I think dollar amounts typically work best because if you've obliged them to spend $50,000, their own self-interest means they're going to spend the $50,000 in the best possible way. If you try to tell them that they have to run this kind of campaign on this platform or for so long or these social medias, these influencers, I feel like that's hard to predict. For all you know, you were focusing on Twitch, but it ends up being a YouTuber who really makes your game go viral. So trying to predict that ahead of time can be difficult, and the publisher may have their own ideas. They may in fact know more about marketing than you do, so you may want to just stick them with a budget, and then as I say, their self-interest means they're going to spend that budget as best they can. But let's talk numbers for a minute. So, net revenue means the amounts actually received by publisher. Up to here, this is pretty standard. All they're trying to say is until we have the money, it's not revenue yet. from the sale of the game, so again, here we're presuming there's no advertising funding. So you've got to wonder about this depending on your business model. It may or may not make sense to talk about sale of the game, or sale of the game, this doesn't mention related content. Remember, related content is something that they have an exclusive license over, and it's soundtrack when sold separately, DLC. So if you read this contract literally, they basically have an exclusive right to monetize the related content, but it's not part of their revenue calculations. That's a problem. So this should say sale of the game and related content. So whatever they have in terms of IP rights should sync up with what they have to pay royalties on. Those two things should always be the same. There's no reason there should ever be a discrepancy there. Why would they have IP rights but not have to pay you royalties? And why would they pay royalties if they don't have IP rights? So those two things should normally sync up throughout. So you see, let's just assume we fix this. So we have a good revenue base of what's coming in. Then, because this is based on net revenue, or another word would be sort of profits, so it's revenue minus, and then you'll get a whole bunch of things that are subtracted out. And what isn't listed here, they're not allowed to deduct. So what you want to be careful with is, from a developer perspective, what's listed here should be reasonable and should be concrete enough that we can all agree on what that means. So taxes is a very common deduction for sort of taxes at source. If there's any kind of sales tax that's been taken off, obviously that doesn't go to the publisher, so it can't flow through to you. So this is pretty standard, and that's reasonable. And then here, another series of deductions. So platform revenue share amounts, anything that's skimmed off the top by Steam or some sort of mobile store, obviously that's never going to the publisher's pocket, reasonable to exclude it. Credit processing payments, again, this is reasonable, depends. Typically that's going to be bundled in with the platform, but sometimes depending on where you're selling, it's going to be different. So any kind of payment processing fees, chargebacks, anything that again isn't going in their pocket should legitimately be carved out. Credits issued to customers for returns or refunds, this is again pretty standard. Sometimes you'll see this as a conventional number, like they'll say we're allowed to budget 3% for returns or refunds in a given period, and then we'll make up the difference in the next period. Tends to be more of an issue with very large corporations where 3% of millions of dollars is a huge amount of cash on a monthly basis. But with digital, it's a lot easier to do this in real time. So you may or may not see it depending on who you deal with. Marketing expenses. This is where it becomes important. That means that if they have $10 and they spend 3 of them on marketing, you're getting rev share on $7, not $10. So that means $1 on marketing is $1 you will never see anything about. So that goes both ways. You want them to market, but typically the marketing comes out of your revenue share. And I think that's fair because it's money that they've sort of put into pushing your game forward, but you got to make sure the marketing budget makes sense. It's not too high, it's not too low. And typically what you might say is you need to spend at least this much, and we'll authorize you to spend up to this much. Beyond that, it doesn't count as a marketing expense unless we pre-approve it or agree otherwise. So you might say minimum $50,000 budget, and max $200,000. But if you go over $200,000, we're not taking that out of this calculation. Yes.
Two questions. One is, if you have a license fee for an engine or a piece of technology, is that counted in the platform revenue share?
So typically no, because this is the money they're getting. So that's something you need to think about. Is if you have to build in, for example, a license fee you're paying to say Unreal, for example. Unreal is a good example. That's money you're paying. Maybe it's being skimmed off the top by the platform, but depending on what platform you're selling on, it may or may not. You may have to pay later. And so that's something where you need to find a way to credit this to yourself. Like if you're paying 10%, you and the publisher should be sharing that amount. So $10 of revenue, really there's $9 that's coming out. And then 10% goes to the licensor. Because if you fail to address that, you're paying 100% of that yourself. So that's what you need to make sure of. And there's different ways you could split it. The publisher might say, okay, we'll each pay half of the cost. And so you sort of add back an amount into net revenue. Like they say, you pay it, but we'll credit this amount up, and that's how you'll get it back.
And the other thing that's kind of seems weird to me is like, so the marketing expenses are reduced to the net revenue, and then the net revenue is shared based on the share on the splits that is written under.
Yep.
That include the spending they made for marketing.
Yep.
So they get paid twice for that.
So that's another issue, is that you can get something like that where effectively you have double counting. This may be just sloppy drafting. They've stitched, like I said, this is a Frankenstein monster deliberately. we've stitched multiple contracts together, that doesn't quite work. There is in effect a double counting because they're recouping based on marketing expense. So they can push your recoupment milestones out while also deducting these amounts. In practice, this is the more important of the two because it's affecting, it's a dollar out of this calculation. The effect on the recoupment rate is not as important just because you're still getting revenue share, but it's a form of double. It's not literally double counting, but they are getting two benefits for every dollar they spend. The dollar they spend is coming out of your revenue and is pushing you between $1 and $3 further away from the next recoupment milestone. Yeah.
You have control about their marketing expenses. Can they charge like $200 an hour, like a lawyer, like very high?
So that's where you would want to do a much better job defining this. For example, you might say reasonable, you might say standard rates, you may say third-party marketing. Well, I'm not going to give you anything for your internal expenses. So at the very least, you either want to limit it to third party or you want to carve out overhead, like sort of their chief of marketing. You won't be paying a share of his or her salary. There's no reason that should be deducted here. They are their big publisher, they have a chief of marketing. You only want to be paying for specific initiatives dedicated to your game. And then, like I say, you can try to limit what they do with the money, but typically it's better to limit it by dollar value. And then normally self-interest means they'll spend those dollars efficiently.
Would it be worth it to carve out in that the money for events, like specific events that you'd want to go to with your game, like say you're going to PAX for sure, or GDC?
Yep.
Would it be worth it to?
When you say carve out,
like specifically mark out the dates that they're paying for you to go to those events.
That's a good point, that a lot of marketing ends up being your team going to events, and you want to make sure that they're willing to pay for it, because if they haven't said they will, you have no guarantee of how they're going to allocate their marketing expenses. Like I say, typically the publisher says, that's my specialty, let me handle this. But if you want to have a deal with them where part of the marketing expense is paying for your team, make sure that's in the contract. Otherwise, it'll depend, and if they just decide no, well, you're on your own.
Yeah.
You may also want them to pay up front rather than you having incurred the expenses and ask to get reimbursed, because that's just a pain in the butt.
Yeah.
Michael, we have about 10 minutes and then we have to clear the room.
Understood. So, fortunately, we're almost done the business terms, and what we can do with the legal terms is going to be go over them relatively quickly. The last thing I would say is keep in mind what happens if they sub-publish. Like often in China, they're going to work through a local partner. This is quite vague as to what the heck that means. Make sure that you're getting a good split of whatever comes out of a foreign country. Often you'll see something that says any sub-licensing or sub-publishing deals, we just split that money 50-50. That can be regardless of other rev share or just some sort of special provision to make sure that you don't have like a chain of publishers that ends up reducing your amount to almost nothing. Because otherwise, imagine if your publisher is getting half from the Chinese amount, you're getting 30% of 50%, you're down to like 6%. So you want to make sure that you're not 6%, 15%. You want to make sure that you have something that's fair based on what kind of risk they're incurring, because if they're not doing the activity themselves, if they're sort of contracting out to another publisher, they're incurring a lot less risk. They'll make less money, but you should then split that money differently, because the typical splits that you see here are based on the risk that they've taken by financing your game and putting it on platforms. It's quite far down, but like I say, I'll try to make it a little bit faster from here. And these questions are good, and I'm happy to stick around and answer more of them. Revenue share payment, one of the things that Jason mentioned was when are you going to see the money? This is actually super important. This is set up as quarterly payments. That means you're waiting potentially 3 months to the end of the quarter, and then 30 days within the end of the 3 months. But within that quarter, lots of money hasn't been paid yet because Steam has its own delays. So the purchaser, your publisher only gets it the next quarter. You got to wait till the end of that quarter, and then 30 days after that, you'll get a check. Be careful with this. Make sure that ideally, in a digital era, if you're selling digitally, you should be paid monthly. Nothing prevents that from happening. Maybe a reasonable delay after the end of the month, but things should trigger on a monthly basis. Then this is where audits come in. If you're getting money, you should ask for 2 things. One is what's a so-called royalty report. They may give you direct access to their Steam statistics, in which case you can calculate the royalty yourself. Otherwise, ask for a royalty report, which just justifies how they came up with the number that they've put on the check. Then a right to audit. There's lots of audit clauses on the internet. They're pretty standard. The main thing to pay attention to, depending on who's being audited, can the auditor work on contingency? If you're the one being audited, you do not want a contingency auditor, because then it's costs nothing to the person who triggers the audit, and when an auditor is working on contingency, it's a bit of an incentive to dig, because they keep 25%, half of whatever they bring in. If you're the one who's going to be doing the auditing, this is a great idea because it costs you nothing. You can hire a reputable accountant who's going to go nuts looking for missed payments. Keep that in mind. That is one of the most important things in an audit clause because in practice it drives how easy it is to audit the other side. Are you paying KPMG $10,000 for the audit, or are you paying, you know, an independent auditor $0 unless he or she finds something? One other thing, you'll often see something that says if you don't like an invoice, you have to dispute it within X days. Otherwise, it's deemed received. Be really careful about this. It means if you find a problem later, there's nothing you can do about it. There's basically a limitation period that ran out 30, 60 days after the invoice was delivered. These kinds of clauses, you often see them. I don't think they're particularly fair, but just check, because often they're embedding a limitation of liability in the payment terms. So it also means you better check the invoice pretty carefully, and you better insist on a good royalty report. Quick note on withholding taxes. I'm not a tax lawyer, but what you need to know is often cross-border flows of cash, someone has to hold back some money because the taxman wants to make sure that there is a payment. So if you're not in the country and money's being sent out of the country, the person who is in the country has to hold some of it as a guarantee that you'll make up your tax liability. This is really an accounting issue, but just be aware of it because you need a way to deal with this, and it can result in anywhere from 25 to 33% of your money not getting paid to you because it has to be held back for tax reasons. Depending on the structure in the country, this may be easy. There may even be a tax treaty that means that you don't actually have to hold it back. Just be aware of that. That's why often these clauses aren't 3 lines, they're like half of a page. Because again, it's taxes and it's a lot of tax. Termination, I'm really just going to talk about this part here. So forget how long the agreement lasts, but when can you get out of it? I mentioned material breach is a popular way of saying, look, if it's a bad breach, not just you're a little late, or not just there's some problems with the milestone, but if there's a really big problem, 30 days, you have to fix it. This is standard, it's quite vague, so just be aware that the vagueness can play for you or against you depending on what position you're in. Next one you'll often see is if someone's insolvent, bankrupt, tries to avoid bankruptcy by seeking creditor protection. These clauses are invalid under both Canadian and American law, so you can just ignore them. They may be valid in other parts of the world. I don't know all 180 odd countries, but you can skip them because they're just not enforceable. Now here, I told you some words are magic. These are some magic words. Terminate for convenience means I can terminate for any reason, and I don't have to tell you why, and it's valid. I don't need a reason. That is a really big problem if you're relying on rev share as the way that you're actually going to make money. So if you ever see a termination for convenience provision, you should be pushing back on that because it means without giving you any reasons, they can end the contract. As I say, the example I gave of the American publisher who had the code in their own development environment, that's exactly what they used. They had a termination for convenience that started, I think it was a year after the final build, and on 366 days, bang. They terminated it according to the contract, and they were allowed to do it. And there was nothing you could do at that point. Yeah?
When they terminate the contract, they lose also the license they have on the IP.
Typically, this one, that's what would happen. Except you'll see there's like I have quite a long liquidation period, so they get 180 days after termination to liquidate stocks. What does that even mean for digital? This is an example of ambiguous drafting. Basically just they get a free 6 months. My example with the American publisher was a more traditional publishing agreement where they owned the IP, so there it made sense for them economically to terminate. Here it may make less sense because they are losing out at the same time. But let's say they bail on your project because they're not confident in how the development is going, or they don't want to spend the marketing amounts. They can pull the plug at any time. So that's not something you want to be facing for the most part. Typically, if you trust each other enough to get into the business, you should have a good reason to get out of it. Reps and warranties?
So sorry, your recommendation is to not have a convenience out at all?
Normally no, just because, like I say, if you want to terminate the contract because the other side isn't keeping up with their obligations under the contract, you're going to say, like, you got to meet these objective targets. So if you have objective reasons to get out, they should normally have objective reasons because the convenience is just so open to abuse, and there's nothing you can do about it because you agreed to either of us can walk away at any time.
In the termination, again, it's written that they have 180 days to sell everything.
Yep.
Is the rev share still working during that time?
That's ambiguous.
Yeah.
Again, for something like this should be relatively detailed because it's essentially a mini contract governing your relationship as it winds down. So here, a bunch of things continue, but it's not clear about the others. This is an example of something that's just too vague to be helpful. Trying to crunch this contract into a reader-friendly size means they've left out questions like that just cannot be addressed in something that short. And also, existing stocks is written as if this is physical games in boxes at a retailer, but they're selling digitally. What does that even mean? It's a good example where if you read things carefully, you ask yourself some common sense questions like that, and you can't find an answer in the clause itself, then the contract needs some work. As I said, I'm just going to go through this relatively quickly. I've got 5 minutes, so what I'm going to do is reps and warranties and a little bit of what follows. Reps and warranties is like a guarantee. Just as you can have a warranty that your washing machine will not break for a year, you can give a warranty that your game doesn't have any bugs, that it doesn't contain third-party material, that there's no open source viral licenses in it. You're basically saying this is true, and I will, if it's not true, I'm going to compensate you for any damages you might suffer. Usually publishers typically have a couple of reps and warranty. These are usually useless. Like, these don't really matter. You're never going to sue them by saying that, oh, you told me you existed, but you don't. That's just not helpful. On the other hand, they will make you say all those same useless things, and then they'll make you say some things that actually matter. Notably, you're typically going to be guaranteeing that you own all the IP. There's no third-party IP. If some third party shows up, you will cover them for that. Imagine they get sued. This is less of an issue now than it used to be. They get sued by an American Patent Troll that alleges that the game has a monetization mechanism that they've gotten by a covered business patent, whatever. You're on the hook for that. You got to pay the American lawyers. The publisher can turn around to you and say, you told me this wasn't true, now you have to pay for that. Be aware that this is typically low risk but high impact. If one of these situations occurs, especially the IP related ones, you're on the hook. That's a big deal. It may not occur. In fact, so far for none of my clients haven't had that problem, but you are acting as an insurer for your publisher.
Yeah, I think at the indie level, the biggest thing is having contributors and contractors that have not assigned their IP. So you have a friend that did some animations in the game, but there was no contract, there was no IP assignment, and then you're warranting that, oh, you got the LP. But that's really kind of the problem.
And so for those who were at the IP talk I gave a couple of months ago, that was the scenario we covered, is that you have to make sure that all of the things that are flowing into your game, you have some documentation by the person who created that, if it was a person rather than say a company, that you own that. Or at least that if it's a license for an engine, that you have the necessary license. Indemnification is sort of the mechanics that implements the reps and warranties. Indemnification is legalese for you will make me whole. You will pay whatever money I need to make up for the failure for your warranties and reps to be true. So read these two things together, and keep in mind that essentially it's like a mini insurance contract where you're providing the publisher with insurance, but he or she isn't paying you any premiums, so be aware of that. Limitation of liability, Americans love their all caps. Typically this is going to try and exclude all sources of liability whatsoever, except breach of reps and warranties or breach of the indemnification. There's another thing that should always be there, which is payment of your rev share. Your rev share should be carved out of this. The publisher shouldn't have an apparent out to not pay rev share because you excluded all liability. And so again, this is one of the reasons I tell you, do not use this contract as a model. There's all kinds of problems that have been included in it so that we can talk about them. Now, quite briefly on the miscellaneous, a lot of things get thrown at the end. Some of these things matter, some of them don't. The ones near the bottom, most of the things after force majeure don't really matter, they're just legalese. This stuff does matter quite a bit. What law applies? Ideally, you want Canadian law because you guys are Canadian, you know it better, you have lawyers who know Canadian law. You almost never win this fight with the publisher. The publisher will say, my home law, I want home base advantage, home turf advantage. The publisher will usually win. Same thing for jurisdiction. The publisher's going to say, if we get into a fight, no one wants that to happen, but we're going to have to go to my home turf. Time is of the essence. This is another magic word. This means if you miss anything, any deadline, even 1 day, even 1 minute, if they've told you when within the day you have to deliver it, you've breached the contract, they can terminate the contract. This is a magic legal phrase. There was a great British case where a guy was stuck in traffic and he missed a real estate closing by 15 minutes, but because there was a time of the essence clause, the deal was off. So that is really a term of art. It means something very specific. It means all deadlines are hard deadlines. So if this is anywhere, you'll see it's one-sided. The publisher can be late with the payments, but you can't be late with the deliverables. You need to worry about this. Assignment, pretty typical to see something that says no assignment. What you need to also realize is you guys may need to assign the agreement if you have a merger, if you're trying to reorganize your company, maybe by creating a new company because you're bringing in new shareholders. Make sure that there's some sort of mechanism here that says that assignments to related parties are okay. For example, if you got into this agreement with sort of one company, but really the development's happening with another company, you're going to need to assign it at some point. Just make sure that there's an out, at the very least something that says with consent the agreement can be assigned. and there's no reason they should refuse consent if it's a reasonable assignment within the business group. Finally, force majeure. This one, this is pretty typical, very vague definition of what is force majeure, and it's up to you to either accept the vagueness, because probably you're the one who's going to suffer force majeure, because you're the one working on a game with employees that might get sick, data that might get lost. Typically, these provisions are to your advantage rather than to the publisher's advantage. So see if you can put one in. I mean, also just ice storm. Like imagine you have one of those, like the 1998 ice storm, where power goes out to Montreal for several days, comes back very slowly. Everyone's trying to deal with their own home getting reheated. This is the kind of thing where Montreal could suffer force majeure, whereas a publisher in California, yeah, I suppose they're not doing so great. But you can understand that this is much more likely to have an impact on the developer and the publisher. Typically, if they're sophisticated, it will continue. If they're not, it will stop here. You know, hey, if you've got a delay or an impossibility, it's not your fault. Fine. This is where the publisher will say, okay, fine, you're excused, but if it goes on too long, or if it ever makes it impossible to perform, I get to terminate the agreement. That can be fair, or it might not be fair. One of the problems is, much like with deliverables, having a one-size-fits-all delay is not easy. Is it 30 days? Is it 60? Is it 15? You've got to negotiate this and try to find something reasonable. Obviously, part of the point of having a force majeure is if there was ever a fire and you lose all your data and you're trying to reconstruct it from backups and different sources, you need time to make that happen. On the other hand, if it's going to take 6 months, it is sort of reasonable for the publisher to say, look, bad luck for both of us, but we need out. So, next one would be just very quickly, entire agreement means whatever's in this agreement, that's the only thing we've agreed to. So no looking at emails, no pointing to meetings or phone calls or anything like that. This is the agreement and nothing else. This is, again, something that's sort of a magic or a word or term of art. If this is in here, make sure that everything you care about is also in the contract. And these are pretty common clauses. So again, it's a question of trust. If someone says, oh, we agreed into an email, don't worry, don't get the lawyers involved, it's going to be too expensive. 2 years later, this could be a real problem for you because that email is not in the contract. The balance of this is sort of legal fluff that largely doesn't matter. Like this stuff is all technicalities that in very few cases will ever matter with your business. And if it does, it's only because you're in litigation. And if you're in litigation, well, the contract hasn't served its purpose. And that is basically it. We've gone through a bunch of business clauses and a bunch of legal clauses. And if you have any questions, please feel free to ask. I really appreciate your time.
Thank you very much.